Hi, everyone, to all 23 of you, the faces on the screen. Um, so we're very happy, Mel and I, to be here today to go through, she's there, on about general sponsorship and visa compliance. So by no means this, I guess, captures everything in the Migration Act, but we're always here for further questions. And I think hopefully the session will be useful to give you all a brief, an overview of what to look out for and what compliance, this means to the business. So I'll just, before we start, Caroline will have a few points to note on just welcome and housekeeping. So I will let Caroline just take over.
Perfect. Thanks all. Thank you for joining, and a big thank you to AI for running today's session. Hopefully, you will all learn something new today about the world of compliance and our obligations as an employer, bringing in sponsored migrants as well as employing non-Australian nationals. I have a Slido open. I'm just going to share in the group chat if any of you can open, or if you would like to ask any questions along the way. There is a Q&A at the end. I'm happy to ask on your behalf if you don't want to openly ask yourself. Likewise, if anything comes up that maybe you have a thought on how we're currently doing things or querying anything in terms of our internal practice, happy for you to drop a comment in the chat, and yeah, we can take this offline, and I can follow up in our town hall next week. But yeah, feel free to jump on and pop any questions in along the way.
Okay, awesome. Thanks, Caroline. So let's move on to the start. So today's training will go through all of these. And so after this session, we will send through the slides and the recording as well. So you can have a copy of it and refer to it as you go along. So we'll go through the sponsorship obligations and talk about the relevant migration regulations. So yeah, so this is a snapshot of the table of regulations. And throughout the slides, we'll go through them in more detail. So what it means to cooperate with inspectors, to ensure equivalent terms and conditions, paying travel costs, to enable your sponsored foreign employee to leave Australia, and the business must pay costs incurred if required, to keep records, to provide records and information to the minister, to provide information to immigration when certain events occur, to secure an offer of reasonable standard of accommodation, to ensure that the primary person works to participate in the nominated occupation program activities, and to make sure that they work in the nominated occupation and which costs can be transferred, and to not engage in discriminatory recruitment practices. So just going on to the next slide. So this is an overview of what it would potentially mean to business if there was penalties incurred due to employers not being compliant. And so this is what an overview of what happens when there's an infringement notice, how it is enforced, and the civil penalty offense, whether it's civil or criminal, as different penalty units and different costs are sort of aggregated or appropriated, and what both element and the fines and the specific fines. So as you can see, corporate fines are quite large. Not to scare you guys, but it is something that is I guess often overlooked, that you don't realize in your day-to-day that certain sort of actions or what the business is doing could potentially incur really serious consequences through the penalties if they're found to have breached their sponsorship obligations, and just obligations in general in terms of employment. And so I'll just go on to the next slide. Thanks, Steph. Main one, so we've listed down some main risk areas where the employer is the stakeholder. So one of them is employment of individuals without the appropriate Australian work rights. And there's been a couple of cases in the courts about this where it really showcases the importance of vivo checks and making sure that the employees that we recruit have work rights and are working accordingly to their visa conditions, if they have work restrictions, and so on and so forth, which we'll go to in more detail throughout the slides, specifically to Ramsay and the specific occupations that would apply. So the specific acts are also there, and you can also, if you are curious, you can also look this up as it details a bit more about what a work-related condition means, and what reasonable steps that the business has taken and it's not reckless, and so how the business can ensure that they are having best practices to not breach this regulation. So, and then the right side is the possible consequences of a breach, which is depending on the offense and what that entails. So go next slide. And another risk area is the breach of privacy law and failing to obtain permission to conduct work right checks. So this is where vivo checks are important, because the consent of the employee, is very important, because there has to be consent obtained from the employee before private and confidential information, personal information, is retrieved. So, and then the right side, the possible consequences. So we have service agreements and letters to protect from our end. So if we were to obtain a vivo check, we would have to have a letter or a consent written by the person that we are conducting the vivo check for. And next one is the sponsor obligations. And so what that means, we'll go through in more detail what the sponsorship obligations are. And on the right side, it will involve cancellation of sponsorships and bar against further sponsorship activities, and monitoring, infringement notice, publications, and civil penalty orders if the business has been found to have sponsorship obligations. So go to the next slide. So I've just put a snapshot of the new bill, which you might have read about in the news. So there's a new bill that's been passed both houses and will become part of our legislation. And so this is the current attitude of Department of Government, that they want to tighten up and ensure that migrants are given appropriate protection, and employers are employing people who actually have work rights and not coercing them or creating other types of pressures or influence that would enable them to work unlawfully. So this means that there will be an increase in civil and other monetary penalties. So when this new migration amendment strengthening employer compliance bill comes into force, this would mean, and we're seeing this coming through, will there be an increased scrutiny and regulation on how businesses are employing people and what their employment practices are. So it's good that we're all aware and making sure that we have safeguards and rules in place before the bill comes into effect. So next slide. Thank you, Steph. So now I'll go into a bit more detail on the regulations that I was mentioning about earlier. So every employee must provide evidence of Australian work rights. So this is before you let someone through the door. When you are talking to your potential candidate during your recruitment, the first question, if they're not the first question would be, what are their visa status? So are they an Australian citizen, which is evidenced through an Australian passport or other travel documents? And if they are, then that's tick box. If you're not, then you go to, are they a permanent resident? In which case, do they have a partner visa, which you'll see in the slides, an 801 visa or a 190 visa, 189 visa, or a 186 visa. So are they holding permanent residency? And if they are, then that's they have full work rights, or if they're not, are they a temporary resident with visa with work rights? And we'll talk about the visa conditions down the bottom part of the slides, where you'll see what visas for those who are temporary residents. So, and do not rely on the visa grant notices because they're not current, and the visa checks should be as current as possible, at least in the last 3 months, because visa grants are not a reflection of the current status. So what should you do? So at least quarterly, so every 3 months, make sure that you are regularly checking the visa statuses of your temporary visa holders. Must have permission because it ties into the law regulations on getting privacy and confidential laws. And you must face the results of the check each time because of making sure that the business has records, because that is also part of the sponsorship compliance and keeping records of your employees. And if the person does not want to provide a passport or a visa grant, we would suggest that you undertake a supervised visa where your candidate or employee does this in front of your manager. So that it can be completed and signed off. Just on next slide. Thank you, Steph. So the other sponsorship obligation is to ensure that the employee is employed on terms and conditions that's no less favorable. So this means that they must be paid at least the guaranteed earnings at the time the nomination application was submitted, and while they hold the visa. So just an important note is that this is calculated over the hours that were submitted. So for example, if they were paid 70,000 over 38 hours, if there's a change in their hours, that means that their base salary hourly rate also changes. So just keeping in mind that there shouldn't be a reduction of salary, because if there is, Home Affairs should be advised. If it's an increase in salary, that's fine, because that's part of reality. People move through the ranks and are promoted, but if there's any change at all in the hours and guaranteed salary, there's a reduction. Home Affairs must be notified, or and there must be a reason for that. So any other conditions must also meet at the time of the nomination application. So for example, non-monetary earnings. So if there was allowances such as budget, travel allowance, motor vehicle, or accommodation allowance. I guess that it depends on case by case. Sometimes you could shift the non-monetary to the monetary if it ends up the same. But if you encounter a situation like that, please come to us first, as we probably would need to advise specifically if there's a change in the non-monetary and monetary proportion that's different. And yes, so we need to consider site allowance and how this could also change between the different locations. On next. So so your sponsored employee must be paid at the same level as the equivalent Australian citizen or permanent resident would be paid. So if there's an equivalent Australian citizen or resident, they must be paid the same as that equivalent worker, as per if there is the award or industrial agreement. So for example, the classification of their roles, or current market salary rate related to their job in the same location. So they must be paid the same. And at the time when we prepared and provide our advice to the application, we would obtain further information from you if we think that the Australian employee is paid a lot more, as this would definitely be an issue. And if the salary decreases, you need to submit a new nomination visa application. So what can you do to ensure that all of your sponsored visa holders are that you remain compliant? So a biannual or annual review, this means that there should be a review of the classifications and the employees and whether there's a difference in terms of what you're paying an Australian employee and what you're paying a foreign visa holder, because if they're both, say, classified as an RMO year one, they should all be paid. The foreign employee and your local Australian citizen should be paid the same if they're doing the same role and classified as an RMO year one, so there can't be discrepancy there. When drafting a nomination application, which is when we send you the draft form as well, so we only include the guaranteed earning, and if there's a range in the particular classification in award, we use the minimum in that range, so to ensure any fluctuations or differences are accounted for. And if there is no award that applies and there is no equivalent Australian, then there would be other market salary rate evidence that we can use, such as job advertisements or any other internal salary pay rate. But if there is no award or enterprise bargaining agreement, then and if there is an equivalent Australian, then we would refer to an equivalent Australian contracts and current pay slip. So just to summarize all of this, is there an equivalent Australian? If yes, then specific types of evidence would apply. If there's no, then there's no equivalent Australian. That means that other evidence must be provided. And we will guide you through. If there's equivalent Australian, then you provide either the award rate or the contracts or the pay slips. And if there's no equivalent Australian, then other forms of evidence will need to be supplied. Okay, just on next. So in terms of paying the return travel costs, so this is if the foreign employee has been terminated or requested to cease employment before the term of the visa ends. And if they request for the business to pay their return costs, then the employer or Ramsay would then need to comply if a written request that meets the requirements is requested. So that means that the business will have to pay for their flight and their dependent flight and within 30 days and notify Home Affairs of the payment. But in this scenario, if there's any questions that arise from this, you can always email us. But yes, if they are requested to return to their home country before their visa ends, then the business is obliged to pay if a written request is made. And records must be kept as to the cost paid, who the costs are paid for, and the date of payment is per the regulation.
And it's probably one of the most frequently asked questions from sponsors. A lot of the time when visa applicants wish to return home, they may Google, they may go into forums, they also call the Department of Immigration, and that is where they will receive advice that they can ask for their flights to be paid so they can go home. Mindful, though, that those flights only have to be from Australia to the country of origin, the country of passport. They don't have to go through a particular route. It's just a straightforward option. They don't have to be first class. They just have to be simply economy class. And obviously, you can't. The sponsor is not required to pay for things like, the relocation costs and things like that. It's just your simple standard inclusions with your normal basic flight. And as Jens said, it's important to keep record once that is done. Sometimes visa applicants will go out there, they will obtain their tickets, and then they'll ask the sponsor for a reimbursement. And in that case, that's perfectly fine too, as long as you keep records of those. And I think, Jen, I might continue.
Yes.
There we go. So it is important that we are notified or that the Ramsay immigration team is notified, because it is one of those notifiable events. So it is very, very important to let us know, or the Ramsay immigration team know, when these particular events happen. As a rule of thumb, anything that has to do with immigration, if you are not sure, absolutely ask. The compliance field is so important. The Department of Immigration does like to sanction sponsors. And when they sanction sponsors, they also like to do it publicly. So there is a register in the public domain where people can log in and have a look and see which sponsors have been sanctioned. So it is important to be very, very accurate and always on top of the compliance requirements. So records that you should be keeping are things like the travel cost requests, any notifications that may have done for that particular worker that might have left Ramsay and they might have gone and worked for somebody else, or they might have returned home. Any money that has been paid to that particular sponsor, obviously all of the payroll records, the wages or salaries that might have been paid throughout the years, any evidence of any tasks performed, or even any periods where they might have been performing high duties. Sometimes sponsored workers might perform higher duties when they're replacing a manager that is away on leave. That can only happen for very, very short periods of time. Otherwise, it becomes a sponsorship obligation, a breach. But if that happens, obviously keep those records. Certainly any terms and conditions applicable to Australian citizens or permanent residents. And with this, Ramsay is pretty specific and I suppose straightforward as well. Everyone that is on a visa with Ramsay is basically paid in line with the applicable award anyway. So there's no really room for many errors there or breaches. It does become a little bit more complex when, for example, Ramsay is sponsoring someone that is not part of the award. For example, it could be a recruitment, someone in the recruitment team, for example, that might not be part of the award or the enterprise agreement, or it could be someone in the IT team. And that is where we even look for someone that is in a similar role to them within Ramsay, or we go externally and then we support Ramsay with finding the evidence. And we keep an eye on these things as well. So again, we support Ramsay with the intricacies of this particular part of the process. And certainly payroll would have access to then position descriptions, employment contracts, and so on for that particular file. The reason why we need to keep the records, one is part of the obligations, but two, from time to time, the Department of Immigration will pair up with Fair Work Australia, and the inspectors will walk into a sponsor's venue or headquarters and ask for records. They do this so that they can compare and ensure and assess to make sure that the sponsor has been abiding by the sponsorship obligations. So it's very important to basically have those records handy and provide them when requested. If we move to the next slide, Steph. Okay, so we have a list of obligations, and Yen summarized this very nicely on that first slide. So it is important to be very vigilant in any level of the organization. Everybody needs to be very vigilant when it comes to foreign workers. Things like ceasing employment, changing of duties. Sometimes workers, and it happens so often where a worker will apply for a promotion. What they don't know is that that promotion may actually trigger an occupation change. So, for example, from a nurse, they might apply for a job to become a nurse manager. That is a completely different occupation. So they can't just straightforwardly get the job, because what that will mean is that they will need to have a new nomination and a new visa lodged under the new occupation, the nurse manager role, for example, and they need to show that they can actually do the job. And sometimes they just don't have the experience, even though they're talented and they're great and look really suitable for the role from a Ramsay perspective, they're just not suitable from an immigration law perspective. So it's always good that when a promotion comes through, you run it past us, we can look at the CV, we can look at the role and see whether one, a nomination change needs to happen, and two, if it needs to happen, then whether the worker will be able to fulfill the criteria, get a visa, and then start moving into the role. So that's very important. Other things to bear in mind are things like not commencing work with Ramsay. This is important. I don't know how many of you know, but it is very costly to sponsor foreign workers. The Department of Immigration alone will charge in the vicinity of about $4,000, $5,000 just for Ramsay to sponsor someone on a 482 visa, and then on permanent residency is $5,540. So it's expensive. When they don't start, not so much with permanent residency, but with the 482, when they don't start work after they've been sponsored and the visa's been granted, then we can ask for a refund of the fees, number one. And number two, of course, it's a notifiable event as well. So there's a couple of bits and pieces there that we need to be aware of. The same thing applies to things like changes in duties, hours, employment conditions. Sometimes, for example, we may have a worker or a nurse or a doctor that might be pregnant. In that situation, they might take maternity leave or they might ask for reduced hours. The 482 visa is quite forgiving when it comes to maternity leave, but that's it. They're not forgiving anywhere else. So it's important that if they are asking for reduced hours, then again, we are consulted so that we can give some more specific advice around that. The 28 days is basically the timeline the department allows us to give them to notify for any changes. So let's say, for example, a director of the company has changed. The headquarters of the company have moved. They're now in Perth or Northern Territory. Then the department will need to be notified. Changes, again, employee leaving you, changing in duties, all that sort of stuff. Again, these are all notifiable events the department wants to know. And when they do that monitoring exercise that I mentioned earlier, they will then go and say, okay, so you had, according to our list, you have 30 workers that have been sponsored. Your current list only shows 25. Where are the 5? And if they've ceased work, show us that you've notified us on time of their cessation. So they can get quite particular about those timelines. Moving on to the next one. Yeah, thank you. Okay, so the 3 components of the nominated occupation. So this is very important. So the department, when you're sponsoring someone, the department has assessed them based on a particular nomination that Ramsay has told the department they need. So, for example, a particular hospital may require a surgical nurse. In that situation, then we nominate that particular worker under the nomination occupation of a surgical nurse. So we need to show them that they have an employment contract. Contract needs to be signed, needs to be dated a particular way. And the employing entity must either be Ramsay or one of the Ramsay entities that are associated with the main umbrella with the Ramsay Health. And again, the condition is they must only work with the nominated occupation. Now, it isn't all unfair for sponsors because even the visa applicant will have these obligations listed on their visa. So if a visa holder goes and works, again, I'll go back to that example of a nurse manager. If a nurse goes and applies for a job as a nurse manager, she is effectively in breach of her or his visa conditions because in their visa, the 482 visa will say you cannot work in any other occupation but the one you've been nominated under. So again, it goes both ways. Yeah, both parties are responsible for that particular part of the obligations. If we move on to the next slide. Okay, so these are the things that you can do to ensure that everybody is compliant. So, of course, when you're doing your performance reviews, for example, you make immigration part of that performance review, making sure that basically things have remained as they should be. No duties have changed, guaranteed earnings haven't changed, they haven't moved around, they haven't changed work location, things like that. Now, I want to stop a little bit in the work location because this is a little bit tricky. If a nurse, for example, is employed in Queensland and she moves from one Queensland hospital to another, as long as she remains within that award level, the one that she was nominated for, or if she goes higher, that is perfectly fine. What we do in that case is just to be compliant with the department, we simply notify the department that this nurse has changed location from hospital A to hospital B. But if the nurse changes and goes to Perth and a different award applies, and that award is lower than the initial award that she was nominated under in Queensland, then the new nomination will need to be lodged because all of a sudden she is receiving a lower salary and the department will need to know. And the way they know is obviously by lodging a new nomination. In that situation, there will be costs associated with that change. Obviously, professional costs from our side, but also Department of Immigration costs. So it's very, very important that you're aware of this in case you come across something like that. Next slide. Okay. Now, there is also some very, very important obligations as far as recovering costs. So the Department of Immigration, when nominating a nurse or a doctor or anyone else in any occupation for that matter, there are two sides of the application. There is a nomination and there is a visa. Ramsay pays for all of the nomination costs, and it does so because it is a requirement under immigration law that the sponsor must pay for any sponsorship and nomination costs. The sponsor, Ramsay in this case, will not have an obligation to pay for the visa-related costs. So if someone, for example, is lodging a visa, they will have to pay and can pay for the cost of lodging that visa, including professional fees for themselves as well as their family members. And that is important. Sometimes the workers may come and ask the sponsor to help them with the fees. Perhaps they're in a difficult financial situation. There may be an agreement for a loan between the sponsor and the visa applicant. That's perfectly fine, as long as none of those costs apply to the sponsorship and nomination fees. We've had cases where these applicants will say to the employers, don't worry, just sponsor me and I'll pay for everything. Unfortunately, as much as they want to, they cannot. It is very, very important that the employer pays for their side of the application. And this also includes things like recruitment, advertising, screening costs, relocation costs, anything like that. Unfortunately, the visa applicant cannot pay for those. And the department, again, will ask for evidence of those. So in that, they usually send you a 10-page list of requirements. And in those, they will say, okay, show us that you've paid for the cost of sponsorship and nominations. And this is where we then assist the sponsors with the evidence. But it is a big list, that one, and this is one of the requirements. Next slide. The sponsor will also need to pay things like training, any pre-agreed costs, airfares, travel costs, things like that. And that, of course, includes now, you don't have to pay travel costs for when they come to Australia to start the job. I do know that there is certain arrangements within Ramsay and other sponsors of that. The industries do this as well, but it is not a requirement under immigration law. It is a requirement if they want to go home. Okay, this requirement is pretty straightforward. Obviously, it is in line with Fair Work Australia. The department has pretty much just lined up their requirement with those of the Fair Work Australia in every Commonwealth, state and territory law. So that's pretty straightforward. Okay, and then we've got some caveats and visa conditions. Now, the doctors are a little bit different in terms of their movements. So while the nurses cannot change locations without notifying the department, they can't go and work with another hospital, and that's very important. So if a nurse is employed by Ramsay, if she gets a job with a state hospital, they can't just straightforwardly go and work there. They will have to be nominated by their particular hospital. That particular hospital will take over their visa, and then they can start working. And the same with Ramsay. So if, for example, you find a talented foreign worker that is sponsored by another hospital, you need to do a nomination transfer. You just can't take over a 482 visa holder. That would be in breach of their visa conditions, and so would Ramsay. A nomination has to happen. We will need to lodge an application. Labour market testing has to happen if it's required, and off it goes. But the doctors are different. The doctors are different because in their visa conditions, they're allowed to work for anybody. So it doesn't matter that Ramsay has sponsored them. The department provides doctors with some flexibility around who they can work for and how long for. So the doctors can actually work for Ramsay, even though they might be sponsored with another hospital. So just bear that in mind. Now, there is a health workforce certificates. These are certificates that are issued by the Department of Aged and Care, but it is now going to be removed, I believe, from the 16th of September. So at least it's one less requirement that Ramsay has to deal with when it comes to sponsoring doctors. Next one. Okay, so here is that beautiful condition that I was talking about. So it locks you in, when you have a 482 visa, it locks you in with your current employer, and it also locks you in with your nominate occupation. Again, it doesn't apply to your doctors. That is very, very different. The minister has provided some exemptions to allow that flexibility for doctors. Now, let's talk about some other visas because, well, let's face it, they're a bit of fun. Working holiday makers, I'm sure you've come across this. It is very commonly called the backpacker visa. It is designed for a particular age group, generally below 30. And it is targeted towards some countries where Australia has a working holiday visa agreement. And what it does, it is designed to allow young people to come in, visit Australia, work, as well as have holidays. The countries are listed on the department's website. We also have a list and materials that we can share around. These guys will come in. They will come in for a year. They have full work rights. So they don't need to be sponsored. The only condition they have on their visa is that they must work with their employer for a maximum of 6 months. But there is a little caveat to that. As long as they work in a different location within Ramsay, then they can work for a whole year, because what they can do is work for 6 months in one location, then move in locations and work for another 6 months elsewhere. These guys also can do some farm work or some prescribed regional work. And once they've done that for 88 days, they can get a second working holiday visa. And if, say, for example, they've worked with Ramsay for 6 months, then they go and work with another hospital for another 6 months. Then they move into the second working holiday visa. They can come back to Ramsay for a further 6 months. So it's a pretty good visa. We love it, and we always advise our sponsors to look at this visa very carefully, because it is a great avenue to hire talented staff, but not sponsor them right away. It enables you to, and them as well, to settle in, to to see whether they're gelling well with the team, they like the role, and so on. And if they would want to stay past their 6 month period, then you can look into sponsorship. So it's a great visa, really. We see this a lot with Ramsay with applicants from UK and Ireland at the moment. Canada is also one of the countries that has the program as well. So does US. New Zealand doesn't apply, but there's a whole bunch of other countries from Asia, Latin America, as well as Europe, that are eligible for the program. And I believe India, and I heard also Philippines might be in the works as well. India has been announced, but nothing has been announced officially. It's just part of the free trade agreement. Same with the Philippines. I think it was announced a couple of weeks ago, but it hasn't really been announced formally in terms of immigration law, but we'll keep you posted with that. Another fun visa is the partner visa group. There's a lot of these, but basically, if you come across these visas, rest assured they have full work rights. They can work for you as long as you want, anywhere you want, in any position you want them to work. That is not a problem. Just consider them permanent residents, really, almost. Australian citizen, New Zealand citizens, permanent residents on other visas, definitely full work rights. No issues with these guys. They don't need to be sponsored. They are fine. They work their own way through citizenship, so you won't need to worry about them. There is a nice little page on the Department of Immigration that lists which ones are the temporary visas and which ones are the permanent visas. So sometimes if you come across that, it's easy to just Google and see what's the 190, if it's permanent or not, but always run your advice through the Ramsay immigration team or through us as well, and we'll be happy to give you support further. Anytime you're not sure about anything with migration, please ask. Very important. Moving on to the next slide. Now, student visas. I know these are a hot topic. They are designed for those applicants that come to Australia to study, and it can be any sort of study. It can be a diploma, a short diploma. It can be a degree. It can be a master's. It can be a PhD. And depending on what they study, they have a certain level of requirements and visa conditions associated with their visa. But the most important one for you is the work rights. So there is a condition called 8105. This particular condition basically limits them to 48 hours a fortnight, unless they are working in the aged care sector. So you can employ students up to 48 hours a fortnight. And this is probably tricky for everyone to sort of monitor, because obviously with shifts and so on, sometimes things can go missing, or you can miss a particular deadline. So it's very important to train staff to ensure that the 48 hours is abided by. This particular group also has their own requirements. Ramsay can't do much about this, but they have to maintain their course requirements. So they have to show up for class. They have to maintain their health insurance. They have to continue to pass their subjects, for example. and a couple of other visa conditions in there that are probably not relevant to Ramsay. Again, we need to keep, they need to keep records. So for example, they need to keep their confirmation of enrollment and things like that, documents they need to provide during their application for a student visa. What is important is sometimes Ramsay or other sponsors will come to us and say, this person is on a student visa and they are telling me that they can work full-time because they finished their study. In that situation, what we ask the sponsor to do is to ask the visa applicant to actually send a copy of their confirmation of enrollment. You see that COE document towards the bottom of the page. Now, that is a document that is issued by the universities. And what it does is it outlines the start date of the course and the finish date of the course. So sometimes students might do this. They all finish their studies earlier because they're brilliant and they finish their studies early, way ahead of the end date in that COE. And they say, okay, well, I finished my studies. I can now work full time. No, they can't. The COE says that they finish in November, for example, then they'll have to wait until November until they can work. It's just one of those things that the department does to ensure that they basically do not work and they do not use the student visa pathway as a way to find work in Australia. That pathway is designed to study, and that's what they should do. Now, the temporary graduates, they have full work rights, so they're great. And the only requirements they have are the maintenance of a health insurance. Again, it's on them. This is nothing to do with Ramsay, but for you, if you see a 485 worker that wants to work with Ramsay, as far as working visa conditions are concerned, just grab them full-time, no issues. Visitors, straight no, can't work. They can study for 3 months, but they cannot work. So if you see a 600, a 601, or 651, it's a no, a flat no. Sometimes these guys will also have a business visitor visa that is designed for them to come in and conduct meetings with Ramsay or with somebody else. Again, no work rights. It doesn't matter. It's a business visa. So very, very important. And that's pretty much it. Now, any questions?
I haven't had anything through on Slido, but feel free to ask away if anyone has any queries.
I do have one. I don't know if you'll be able to answer it, but we'll
Try
see.
me.
So I'll try and put this simply. So when I first came on board, I'm looking after recruitment for pharmacy specifically. And I tried to look into, I guess, the opportunity to look for overseas recruitment and how, if we can implement that within Ramsay Pharmacy. I guess the challenge that I found was a couple of things, that with pharmacists, overseas pharmacists, they have to also go through APRA registration.
Correct.
And there's only a certain amount of overseas universities that APRA also considers as appropriate to come into the country. And that coincides with their visa. I guess what I'm trying to ask is, when I saw you talk about that student visa, is there any way, an easy way for pharmacists to come in where Ramsay doesn't have to sponsor them, and then if they do well, they can continue that visa beyond a 6 or 12 month period? I guess I'm trying to struggle to find a way where I can make this work within pharmacy, I suppose.
Yes. So I'm assuming, I haven't looked into the APRA requirements for pharmacists, but I'm assuming there is those courses that APRA will recognize and will give straight recognition. And then there will be others where the pharmacists will have to go through the motions of getting their, they might need to top up their qualifications, sit the tests, do all of that. Yeah. So the student visa is appropriate for that particular cohort. So the ones that actually have to come here to study, to do an additional course, so they can then meet the APRA eligibility, they actually can apply for a student visa. We see this happen a lot in with nurses, with Filipino nurses, for example, or with physios in the allied health space. They come in, they do a bridge course for 6 months, and they come on a student visa. And then they get their APRA, and then they can be sponsored on a 482 visa. So that's one pathway that you can use. The other pathway, in terms of the ones that are actually recognized from APRA, generally speaking, from experience and working with APRA, I know that the countries that are recognized by APRA sort of line up really well with the working holiday makers countries. So, you know, your UKs, your Canada, Ireland, and so on. So then the working holiday visa can be a good way to just come in and for them to then work, maybe not in that particular occupation as a pharmacist, but they can work as a pharmacist assistant, for example, where APRA might not be required, while they're getting the APRA sorted, and then you can look into sponsoring them. Caveat, they have to have that 2-year experience overseas, because otherwise they won't meet the requirements for the 482 visa.
Okay.
So if you want to, so for example, employ or attract pharmacy graduates, you wouldn't be able to do that because the 482 wouldn't be the right program for them. They need to have a minimum of 2 years of experience. But if, for example, they've done their placements in pharmacy and then they come in on a working holiday visa for a couple of years, then they can gather that experience in Australia and then they can look at sponsorship. Make
and
sense?
once we, yes, that does make sense. And then if we were to sponsor them after their working holiday visa expired, what do you know, what are the restrictions then once that's, what happens from there?
No problem. So basically, if you sponsor them, you can't sponsor them after the visa expires. You have to sponsor them before. And then what happens is when you put an application in, let's say then a 417 visa, which is the working holiday, and then we put in a 482 visa, and then the 417 expires, another visa comes in, which is called the bridging visa A. It will come in because that carries them through until, you know, the next visa is approved. And that visa, we love the bridging visas and the working holiday makers because that visa effectively restarts the 6-month period. So let's say they've worked with Ramsay for 6 months, then we apply for the 482, 417 expires, there's another 6 months on the bridging visa. And you want them to probably last a little bit anyway, so they can stay in the role and they don't have to move, if that makes sense. Yeah.
That does. Thank you very much.
No worries. Anybody else?
Just by perhaps if anyone's thinking of any questions. I know that we had one from one hospital, and it's more just to kind of raise it so you can maybe answer. So particularly around the caveat for doctors, we have obviously a large population of sponsored migrants working for Ramsay. We also have a large population of non-sponsored Ramsay doctors working for us as well. So something that came up that I just wanted to highlight was a doctor who was non-Ramsay sponsored with one of our hospitals. The medical staff or medical admin staff were asking, you know, what our obligations are to the department. I don't know whether or not you want to answer just in terms of informing everybody, just because there are quite a lot of questions around non-Ramsay sponsored doctors and our obligations with the department.
Yep. Well, I think Yannick may correct me here, but my belief is if they're not sponsored with Ramsay, then there is no obligation. But even with their current sponsor, again, there is no obligation to notify technically because these guys are not in breach of their visa conditions. They can move as they please. I would. So say, for example, Ramsay's got a doctor, they've sponsored them and they have moved into another hospital, let's say, you know, the Western Australia hospital. I would still notify the department. I always go overboard with the notifications, even if I don't have to.
Notify them not.
Absolutely. It keeps them, because also if something happens later, I don't know, there is a change in staff and one notification is missed, at least by notifying or over notifying, if it comes to it, we can show the department there's been goodwill and effort made by the sponsor to always notify, and whatever has happened is just an isolated incident.
Yeah, that makes sense.
If I might just add, sorry.
No,
but it's my understanding, and Mel can add, but they should be, if they're on 482 visas, the 38 hours full time is important. Although with doctors they can do part time, but the policy is kind of vague in that sense, and it's always better to notify if the casual, just not working full time on a 482 visa. So it would be the applicant obligations if Ramsay is not a sponsor. Yeah.
that makes sense. And just more of, I suppose, a caveat to everyone on the call. The migration team do monitor any cessations through CRIS 21. So we actually get a report through from CRIS every 2 weeks, this is then, we then work through to ensure that we provide the correct emails and through to the department, and and keep a list and register of those. Any questions then around any kind of general practice or anything else, then please feel free to reach out to migration inbox or shoot us a note. Does anyone else has any other questions? Thank you so much to Mel, Yen, and Stephanie.
Pleasure. And thank you to everyone for attending.